this is going to be a canter through some practical tips on the preparation of applications for interim injunctions. It's not intended to cover all bases. We're not going to be dealing with freezing orders or search orders in any depth, for instance. It's really my attempt, from my experience, both as an advocate presenting these applications and as a judge hearing them from time to time, to give you some tips about what will give you the best chance of obtaining an injunction for your client. And here are 3 preliminary considerations. And the first one should be, do I need an injunction at all? Interim injunctions are expensive to obtain because they're so time-consuming to prepare. And they're easy to lose, particularly if you get procedural. And clients, particularly those who aren't regular litigants, often think that once they've obtained their interim injunction, that's it. Not so, of course. Because in order to obtain an interim injunction, the applicant will have to have either issued proceedings or given an undertaking to do so. For a case where an applicant sought an interim injunction without issuing proceedings or offering to do so, see Jamie Morgan's very recent case of Transparent Limited and Growth Capital Ventures, a TCC case from this year, heard by the head of the TCC. So a client who applies for an interim injunction has to commit to litigation. They have to commit to the issue fee, the months of stress, the uncertainty, and the not inconsiderable costs which must be incurred and may not be recovered, even if the claim ultimately succeeds. All of these things must be borne in mind before the decision is taken to make the application. And so it's always sensible, I think, to consider whether undertakings will be sufficient for your client, at least in the first instance. The next question is, what kind of injunction do I need? Forgetting about freezers and search orders for the moment, there are broadly 2 types: mandatory and prohibitory. And the reason it's important to distinguish between the two is that obtaining the former is a much higher hurdle than obtaining the latter. The court requires, for a mandatory interim injunction, what has been described as a high degree of assurance that at trial it will appear that the injunction was rightly granted. It's a quote from Mr. Justice Gary in a case called Shepherd Holmes and Sander from 1971. Now, ingenious applicants often seek to circumvent this problem by seeking to cloak a mandatory injunction in the language of a prohibitory one. Let's take an example. The defendant ought to be prohibited from having his wall in its current location. Now, that is obviously an injunction requiring the wall to be knocked down, and it will be treated like that. Thirdly, what is my cause of action? It's always important to bear in mind that, except with specific exceptions for injunctions normally provided by statute, an interim injunction is not a freestanding cause of action. It's an equitable remedy available in support of an existing cause of action. No cause of action, no injunction, save in exceptional cases with which we're not concerned today, such as injunctions to restrain the institution of proceedings in the High Court. Once you've decided that you're going to make your application, the next question is with or without notice. And I have 2 rules of thumb here, which I've applied over the course of 20 years without failing. The first is, never apply without notice unless you absolutely have to. And the second is, if you're weighing up whether to apply with notice or without, it will almost always be inappropriate to apply without notice. If you obey those 2 rules, the jurisdiction of the court to hear an application without notice is actually very narrow, and it's contained in paragraph 3 of the practice direction to part 23. And there are only 6 categories of case where an application may be made without serving an application notice. where there's exceptional urgency, where the overriding objective is best furthered by doing so, by consent, with the permission of the court, where paragraph 2.10 of the practice direction applies, which in my experience is virtually no injunction, or where a court order, rule, or practice direction permits. And unless you can bring yourself within one of those categories, the court will simply refuse to hear you. And the first question in practice a judge faced with a without notice application will always ask is this application truly suitable for a without notice hearing? And it's not just the narrowness of the jurisdiction that points against making a without notice application. There are significant disadvantages as well, not least the fact that your client will have to pay for 2 hearings. But the duties on an applicant who makes a without notice application are very onerous. The duty of full and frank disclosure, both in terms of the evidence placed before the court and the submissions made by the instructed advocate at the without notice hearing, are onerous. An advocate in a without notice hearing has a professional obligation to bring all points which might properly be made by the respondent to the attention of the judge. And that duty is a serious one, and it is enthusiastically policed by judges and by respondents. Rare is the case where a respondent to an injunction obtained on a without notice hearing doesn't seek to set aside that injunction on the ground of material non-disclosure. And the reality is that given the speed at which these applications have to be prepared, there is almost always something that could have been placed before the court which wasn't. Cue endless aggressive correspondence between the lawyers, cue allegations of impropriety and potentially satellite litigation. Is it really worth it, you have to ask, when all you have to do is give a minimum of 3 days' notice? And there's a practical point here. Speak to the court before you make your decision about whether going with or without notice. See how long it's going to take the court to list your application. If you can get your application on within a week, and if you tell the respondent immediately the case has been listed 5 days hence, it would be a brave respondent which chanced its arm by doing that which you are seeking to restrain when they know they're going to face a judge in less than a week. The BPC courts in Newcastle are thoroughly helpful when it comes to getting urgent on-notice applications on hearing quickly. And if for some reason they can't get you a judge in Newcastle, they will help you find one in one of the other court centres on circuit. In a with-notice case, depending on the urgency and the nature of the dispute, it's worth considering a timetable for the exchange of evidence and skeleton arguments with your opponent. Again, what you're trying to avoid is the cost and the prospect of 2 hearings where one would do. The next thing to consider is what test the court is applying. Why is that important? Because when you're giving your advice on the merits of the application, and when you're preparing your evidence in support, it's important to bear that test in mind. I've seen too many witness statements which are drafted like a statement for trial, with the entire focus on the facts and the minutiae of the evidence, and nothing at all about adequacy of damages or the effect grant or refusal of the injunction would have on the party making the statement. For most applications for what I would call a bog-standard prohibitory interim injunction, the court will be applying the test we're all familiar with, American Cyanamid and Ethicon, which requires the following questions to be asked. 1, has the applicant shown a serious issue to be tried? 2, would damages be an adequate remedy for the applicant if the injunction granted, or the respondent if it weren't? And if damages wouldn't be an adequate remedy for the party, where does the balance of convenience lie? And that final question is sometimes rephrased as, what outcome would result in the least risk of irremediable harm, reflecting the fact that an interim injunction is always a step taken to hold the ring pending the resolution of the claim trial. Now, there are some variance on that test. In a restrictive covenant case, for instance, where the term of the restriction is likely to expire before the substantive trial, the court will consider the claim, the merits of the claim, to a greater extent than under the American cyanamide test. See Lansing, Linder and Kerr, for instance, in 1991. But it still goes on to consider the other aspects of the American cyanamide test if it's satisfied that there is a serious issue to be tried. And the beauty of American cyanamide is that it provides litigants with a template by which to prepare their evidence and their submissions. So a good witness statement for an interim injunction application should have 5 headings. 1, introduction. 2, serious issue to be tried. 3, adequacy of damages. 4, balance of convenience. And 5, conclusion, and nothing else. I've already covered the different tests which applies when seeking a mandatory interim injunction, and my rule of thumb is this: unless you've got a slam dunk of case, don't even bother to apply for a mandatory interim injunction. What evidence do you need for your application for an interim injunction? Don't forget that for the purposes of an interim application, a statement of case counts as evidence for the purposes of that application. Paragraph 9.7 of CPR Practice Direction 23. I would always suggest that you have particulars before the court by the time the application comes on for hearing at the latest, whether they're required by that time or not. It is far and away the easiest way to demonstrate there is a serious issue to be tried. I've been through what a good witness statement looks like. Always bear in mind the limited reading time the judge will have before the hearing. A compelling case for an interim injunction ought to be capable of being made out in a witness statement of 10 pages or less, I think, save in a complex case. An exhibit should be kept to the absolute minimum. Don't forget, in capital letters, because it is forgotten time and time again, evidence in relation to your cross-undertaking in damages. The cross-undertaking in damages is the price that virtually every applicant has to pay for their interim injunction. And the court needs evidence, not submissions from your instructed advocate, to show that the applicant is good for the undertaking. Don't assume, as some do, that because you can't think of any financial loss that the respondent might suffer if the injunction is granted, that you can ignore the cross-undertaking. In my experience, cases where an injunction is granted without a cross-undertaking are as rare as hen's teeth. Now, how to get it wrong. These are the things that you can do to give your client the best chance of losing. It's impossible to overstate the importance in an interim injunction of getting the judge on side before the hearing starts. Everything that you do to prepare for the hearing should be designed to make the judge's job as easy as possible. Just imagine it's like an obstacle course that you get the opportunity to set. It's a very simple equation. The more obstacles there are in the way of the judge, the less likely you are to get your injunction. So here's how to guarantee your application fails. Firstly, give a time estimate which is far too short. Only give an estimate of how long it's going to take to present your case. Ignore entirely the time for pre-reading and the judge's thinking time and judgment. Say it's a 2-hour hearing, even though you know it's more than that, because you know that's going to get you in the interim applications list next Friday, so your client won't have to wait. Secondly, don't prepare the bundle properly. Don't follow the detailed guidance on bundle preparation that exists in the Commercial Court Guide, the Circuit Commercial Court Guide, and the Chancery Guide. Make sure you include relevant documents. Organise those documents in a haphazard and illogical order. Don't use any tabs or any pagination in your bundle. Thirdly, don't provide a draft order. Make the judge wonder what exactly it is that you're asking for. Make it harder for the judge than simply rubber stamping a document you have prepared for him or her. And finally, don't prepare a skeleton argument. Or prepare one, but don't get it to the judge in time. That way, the only way they can understand what your argument is to fight their way through your overlong witness statement and your overlong and poorly organised book. Do those things, and I can guarantee that you will not get your interim injunction. Do the opposite of those things, and you will have a judge who understands your case clearly, who has goodwill towards you, and has had his or her path cleared to granting your injunction.